My name is Sam Khalesi. I'm one of the directors at GML Lawyers. Been practicing law for some 20 years. At GML Law, we offer a variety of services, from buying and selling a property to a business to matrimonial or court work. So our firm has specialists in every field. So the advantages of buying a property in a trust are different for different people. If you have a business and there is a level of risk involved in your business, it's a very good idea to buy a property in a trust, because the trust is deemed to be separate to your person. So what I mean by that is that a trust is a separate entity to you or your company. So that means that if you're purchasing a property under your trust and your business, for example, gets into some sort of trouble, and or creditors come looking for someone to pin the debt to, even if you personally go bankrupt, for example, generally speaking, the trust property will remain untouched. So that's the major benefit of owning property in a trust. But there's some other ancillary benefits, one of which is from an estate planning perspective. So what I mean by that is, if somebody has children and a wife, and for some reason you pass away, the way that you deal with the person's property is through a will. However, if you have a trust, essentially what happens is the trust continues to work and essentially live beyond the people who set it up. So that means that from an asset protection and estate planning perspective, it's a useful tool, particularly again from protection from people who are involved in your life, who may take a claim against the estate and say, I should have a part of that estate. In New Zealand law, there is provision for allowing people to make a claim against an estate. However, when property is owned by a trust, it becomes far more difficult for that process. And so therefore, the benefits of a trust is that it protects your assets and it makes estate planning a little bit easier. You leave the trust for your children. As I mentioned, a trust is a completely separate entity to you. So there has to be a process from which we transfer your assets from your personal names, and that could be you and your wife, or you and your children, or whomever you have a relationship, ownership relationship with, transferring that to the trust. And there's a legal process to do that. As part of that process, if there is a mortgage, for example, we deal with the banks. We let the banks know that we've set up a trust, that we've registered it with the IRD, that the trust is now what we call settled or established, and that we want to transfer the mortgage from you or your wife and your personal names to the trust. The banks are very comfortable with this process. It's very a standard process now. So the banks have a very streamlined process. We send them the correct information. They send us the mortgage documents, for example. We effect the transfer. So when you look at the title on your property, it will no longer be in your name. It will be in the name of your trust. To give you some comfort though, you manage the trust or you run the trust. And so therefore, there's no risk that your asset is in someone else's hands. You still are not the owner, but you're the manager, therefore, therein of the trust.
Perfect. Thanks very much. And would you mind to just short brief on AML process? Because a lot of people actually, when they want to start a trust to get a mortgage from the bank, the bank is running an AML process. Just a short explanation that what is AML and why is it actually required, and how the customers, they can actually assist bank with the process.
Sure. The AML process is an abbreviation for anti-money laundering, and we have anti-money laundering legislation in New Zealand, which essentially means that there are a number of steps that must be taken with any institution that deals with your money, including accountants, real estate agents, banks, and so on and so forth, whereby they require a level of information from you which is far greater than what it used to be. So for example, they will require as a minimum proof of identity, which is usually a passport and or a driver's license. They will require proof of address, which is usually a utilities bill, somewhere where you can establish that this is my house and therefore this is my address. And then with the trust aspect, it gets slightly complicated because entities want to know where you got that money. And this is becoming more and more common. When you deposit money into a bank, they say, for example, or withdraw, they say, what is it for? Those are questions that assist with their AML. They're not being nosy, that's just what they're asking to assist. So when they ask for things like source of wealth, what we require as lawyers or banks is that you say, or you demonstrate via a letter from either the accountants or the lawyers to say that, for example, in 2020, you sold a house, you realized some capital gains, and that's where that money has come from. And therefore, on that basis, the bank is satisfied that those monies are not what we call black money or what we call laundered money, that it's clean money. And the bank on that basis, or your lawyer on that basis, will accept that the money is clean and allow the transaction to occur.